you may remember the name AggregateIQ. That's the BC political advertising company embroiled in last year's Facebook Cambridge Analytica scandal when private data from Facebook was improperly used to help political campaigns in Britain and the US. Well, the federal and BC privacy commissioners decided to investigate AggregateIQ's role in all of that, and they found the data firm broke Canadian privacy laws. So what did they do, and how can governments prevent it from happening again? Michael McAvoy is the Information and Privacy Commissioner for British Columbia. Danielle Terrien is the Privacy Commissioner of Canada. They both join us from Vancouver. Hi there, nice to see you both. Thanks for making time for us.
You're welcome.
Mr. McAvoy, before we get into the conclusions of your investigation, can you explain for myself and our viewers exactly what the two of you were looking into?
We were looking at the practices of a company called AggregateIQ. It's based in Victoria, British Columbia, here in our country. And AIQ's work has actually taken it around the globe. They found themselves in the middle of some of the more interesting campaigns, if I can describe it that way, the Brexit referendum, the midterm campaign election in the US, as well as a presidential primary campaign. So they were in the middle of collecting and using a lot of information which allowed them to target voters in those elections. As well, we looked at their work in British Columbia and other places in Canada.
And Mr. Terrien, what did your investigation conclude?
Well, we concluded that AIQ's work and services provided to various political campaigns did not rely on appropriate consent, that the individuals whose data was collected, analyzed, and then used for political messaging, all of that was done without appropriate consent by individuals. That was our main conclusion. And in terms of security of the information, we also found that the information of approximately 35 million people, Americans, British Columbians, British individuals, was not protected securely by AggregateIQ.
And so what are the consequences of that, Mr. McAvoy? Are there penalties for this company? What happens?
Well, we made recommendations that they need to change their practices. Now, AIQ has agreed to those recommendations. Both Commissioner Terrien and I are going to go back in over the coming months to make sure that their commitments to change their practices actually has happened. One of the things that this report points to is that the penalties for these kinds of behaviors are not sufficient. We do not have, for example, fine-making power, which exists in many other jurisdictions, including the European Union and in the UK, the kinds of measures that would allow us as regulators to make sure that the public is properly protected. And so those are the kind of changes that have to happen in Canada. Our legislators, whether they're here in BC or across the country, need to make those changes to ensure Canada is keeping up so that our citizens can be properly protected.
And Mr. Terrien, I know I've interviewed you before specifically on that subject, on an increase in the potential powers of the Privacy Commissioner to actually levy some kind of penalty. Have lawmakers in this country been receptive at all to those calls?
On the issue of legislative reform generally, they have certainly taken a lot of time to respond to our recommendations, but in the spring the government issued a digital charter, which I hope is the first step towards legislative change. In terms of regulating political parties, here in British Columbia, there is provincial legislation whereby BC provincial parties are subject to privacy laws. That's not the case federally, and that's not the case in all other provinces and territories in Canada. So another aspect of our legal framework that is failing is that political parties are not subject to privacy laws, and that's another recommendation that we're making.
And if I'm not wrong, Mr. Terrien, just a quick follow-up. I believe I was looking through some of the proposals. I know the Greens proposed that, but I looked through the Liberals platform from the summer, and that was not part of their proposals. It doesn't look like there is political will for bringing that in.
It was not, although a year ago, Minister Gould, who was responsible then for democratic reform, in the context of changes to the Elections Act that were before Parliament, indicated that it was not the time to change privacy laws, but that it might be the time, in her view, to study how the regulation of political parties federally could be done, which she thought was desirable, subject to leaving room for parties to engage with electors. And I think that's the next stage. We should have that study that she seemed to welcome a year ago. Now it's time to have that study.
Mr. McAvoy, let me ask you, because Mr. Terrien brings up a good point. When we had the previous minister on to ask her about this in the past, and other MPs to be fair as well, they did bring up that concern about, well, this might limit my ability to interact with my constituents. Have you found that to be the case in BC?
No, and in fact, it's the opposite. I think where you have robust privacy laws in place that protect people's information when it comes to political parties, what it does do, it enhances the public's confidence and trust in those parties in the system, so that voters know they can have a very candid conversation with their political parties, with candidates, knowing that that information is going to be used properly and not used in ways that they wouldn't expect. So in our view, what privacy law does is it adds and enhances the democratic process and exchange between voters and parties.
Mr. Terrien, if I could circle back to the investigation at hand today, is there anything now within the legislative framework or legal framework or that exists, I guess, in this country that would, beyond sort of the company agreeing to your recommendations, that would prevent or give some assurance to Canadians that their data will not be used for nefarious purposes?
Well, the law that we have, unfortunately, relies on the willingness of commercial organizations to agree with our recommendations. Now, this particular company has indicated that they will comply with our recommendations about consent and security safeguards, so that's certainly better than what we saw in Facebook, but we will, Commissioner McAvoy and I, verify in about 6 months' time whether indeed they have respected their commitment.
I guess, though, Mr. McAvoy, beyond this one company, is there anything that would prevent another company from doing something similar?
Well, in British Columbia, if it's a British Columbia company, we have the authority to make orders to stop companies that engage in these kinds of practices. So the answer is yes, going forward. But I don't think those kinds of order-making powers, which are okay, go far enough. And we need to be keeping up with what is happening around the globe. Even in the United States, changes are happening. California is passing a very privacy-protective piece of legislation going through in January, as well as federally in the United States there's talk. So it's really for Canadian legislators, whether it's here in British Columbia or in Ottawa, to respond to, I believe, what the public's view of this is, and that is that the greater protection is needed so that their information can be used properly and used with some integrity.
Okay, I'll leave it there. Thank you very much to both of you for your time. I appreciate it. That's thanks to Michael McAvoy, Information and Privacy Commissioner for BC, and Danielle Terrien, Canada's Privacy Commissioner. Hi, I'm Vashi Capellos, host of Power in Politics. See more of our show by subscribing to the CBC News channel or click the link for another video.